Offences related to marriage, section 493 to section 498A. Offences related to marriage, Indian Penal Code 1860, section 493 to section 498A. Chapter 20 of the Indian Penal Code deals with offences related to marriage. All these offences are within the institution of marriage. Chapter 20A contains only one section, which is section 498A. It deals with the cruelty to a woman by her husband or her relatives to coerce her and her parents to meet material greed of dowry. It was added to the IPC by criminal law in the amendment done in year 1983. Following are the main offences under this chapter: mock or invalid marriage. It is under section 493 and section 496. Bigamy, section 494 and section 495. Adultery, section 497. Criminal elopement seduction, section 498. Cruelty by husbands or relatives of husband, section 498A. Section 493. Cohabitation caused by man deceitfully inducing a belief of lawful marriage. Every man who by deceit causes any woman who is not lawfully married to him to believe that she is lawfully married to him and to cohabit or have sexual intercourse with him in that belief shall be punished with imprisonment of either description for term, which may extend to 10 years, and shall also be liable to fine. It is non-cognizable and non-bailable. Section 496. Marriage ceremony fraudulently gone through without lawful marriage. Whoever dishonestly or with fraudulent intention goes through the ceremony of being married, knowing that he is not thereby lawfully married, shall be punished with imprisonment for term which may extend to 7 years, and shall also be liable for fine. It is non-cognizable and bailable. In both the sections, woman is cheated by the man into believing that she is legally married to him, but man is fully aware that the same is not true. Section 494. Marrying again during lifetime of husband or wife. Bigamy. Whoever having husband or wife living marries in any case in which such marriage is void by reason of its taking during the life of such husband or wife shall be punished with imprisonment of either description for term which may extend to 7 years, and shall be also liable to fine. Exception. This section does not extend to any person whose marriage with such husband or wife has been declared void by court of competent jurisdiction. Any person who contracts marriage during the lifetime of former husband or wife, if such husband or wife at the time of subsequent marriage shall be continually absent from such person for 7 years, and shall not be heard by such person as being alive within that time, provided the person contracting such subsequent marriage takes place, informing the person with whom such marriage is contracted of the real state of facts so far as the same are within his or her knowledge. Section 495. Same offences with concealment of former marriage from person with whom subsequent marriage is contracted. The essential ingredients are existence of a previous marriage, second marriage to be valid, second marriage to be void by reason of first husband or wife living, non-disclosure of the first marriage. Whoever commits the offence defined in the last preceding section, having concealed from the person with whom the subsequent marriage is contracted the fact of the former marriage, shall be punished with imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine. Pasaura Singh versus State of Punjab, AIR 2010 SC 922. In the above case, it was held that the first marriage should be substituting at the time of second marriage and should be validly contracted one. If the first marriage is not a valid marriage, the second marriage does not amount to bigamy. Section 497. Adultery. Adultery is a sexual intercourse between a married person and someone other than the lawful spouse. Under law, adultery is defined as a consensual physical correlation between two individuals who are not married to each other. Adultery is also known as infidelity or extramarital affair, which is certainly a moral crime and is being considered as a sin by almost all religions. According to section 497, whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be wife of another man without the consent, connivance of that man, such sexual intercourse not amounting to the offence of rape is guilty of the offence of adultery, and shall be punished with imprisonment or either description for a term which may extend to 5 years, or with fine, or with both. In such a case, wife shall not be punishable as an abettor. The essential ingredients are sexual intercourse between a married woman and man who is not her husband. Woman must be married, sexual intercourse by a man who is the wife of the another man. Sexual intercourse must take place with the woman consent, that is, it must not constitute a rape. Sexual intercourse with married woman must take place without the consent or convenience of her husband. Section 498, enticing or taking away or detaining with criminal intent a married woman. Whoever takes or entices away any woman who is and whom he knocks or has a reason to believe to be the wife of any other man from that man or from any person having the care of her on behalf of that man with intent that she may have illicit intercourse with any person or conceives or detains with that intent any such woman shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Essential ingredients are takes or entices away woman to be a married woman. The person enticing or taking away the married woman should have knowledge that she is the wife of another man, taken from control of husband or person having care of her on behalf of her husband, intention to have illicit intercourse, conceals or detains any such woman. Alamgir was the state of Bihar, AIR 1969 SC 436. It was observed that while the wife is living with the husband, man knowingly goes away with her in such a way to deprive the husband of his control over her, with the intention to have illicit intercourse, then it constitutes an offence within that section. Section 498A, cruelty by the husband or relatives of the husband. Whoever being husband or relative of husband of a woman, subject such woman to cruelty, shall be punished with imprisonment for term which may extend to 3 years and shall also be liable to fine. Explanation. For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health of the woman, or harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawfully demand for any property or valuable security or is on account of failure by her or any person related to her to meet such demand. For safeguarding the interest of a woman against cruelty, the Indian Penal Code 1860 was amended in 1983 and Section 498A and Section 304B was inserted, which deals with the matrimonial cruelty to a woman by husband and his relatives and dowry debt respectively. Section 113B was added to Indian Evidence Act 1872, wherein it was provided that if it was shown that soon before the death of the woman she was subjected to cruelty or harassment by person in connection with demand for dowry, then it shall be presumed that such person who harassed the woman had caused the death of the woman.